Three, two, one, action. So I came to Sauble Beach for a summer job in 2003. I was there to print t-shirts. The store next door, I did body piercing, which I immediately became enthralled with, and then eventually got an apprenticeship. And in 2005, the store came for sale, and I bought it and turned it into Steel and Ink. We're tight. We're a family. I mean, the fact that, I've grown into a CEO now and the company has expanded to 20 stores, I'm still a body piercer. Before Employment Hero, we had an app for payroll, we had an app for benefits, we had an app for training. It was a scattered mess. Today, we use Employment Hero for absolutely everything to do with employment, from benefits to training to performance and to getting paid. Moving to different provinces, compliance was definitely a big issue for us. Once we got involved with Employment Hero, they took care of all that for us. Training has definitely been the biggest game changer for us. Our staff love Employment Hero. Saves them a ton of time and also lets them know they're on top of things. They could see if their training's up to date. They could see performance reviews. Everything right there in one dashboard has been great. So with all the time I save using Employment Hero, I'm able to focus on expanding the company. As we grow, Employment Hero has helped keep a tight-knit community amongst our stores. So yeah, Employment Hero is one system, everything employment.
Great. Well, I hope everyone enjoyed that little snippet into the Employment Hero platform to kick things off this afternoon. I'd like to welcome Alex Treiber from Treiber Law PC as our guest and expert speaker today on all things how to keep compliant when it comes to AI, which is always a big topic. So again, welcome everyone. And Alex, I will hand it over to you.
Awesome. Thanks, Natalie, for that introduction. And thank you, Employment Hero, for having me today. And thank you all for joining today's webinar. Today's topic is a hot topic. Artificial intelligence is no longer just a big company experiment or a future state technology. For Canadian small, and medium-sized businesses, AI is already here. It's helping draft marketing copy, it's screening resumes, it's automating customer service, and it's making faster decisions with frankly, low overhead. But with that opportunity, obviously comes responsibility. As AI tools become easier to adopt, the rules around privacy, data protection, human rights legislation, ethical use are becoming hard to ignore. For businesses especially, the challenge isn't where to use AI, it's how to use it right, without putting your customers, your reputation, or your businesses at risk. Today's presentation, AI Done Right, Compliance Essentials for Small and Medium-Sized Canadian Businesses, is about cutting through the hype and the fear, and we're going to focus on what actually matters. The key compliance considerations in Canada, the common risks small businesses overlook, and the practical steps you can take to use AI confidently, responsibly, and most importantly, legally. So just a little bit about me. I've been in this labor employment space for a better part of the last 13 years. First as an HR professional at the Ontario Securities Commission, and then I used to practice exclusively for management and employers at a large Toronto Bay Street firm for a number of years. I had a brief 3.5-year stint practicing law at a large law firm in New York City, representing large multinational corporations in a broad range of commercial litigation disputes. I started my own firm about 2 years ago, taking everything I learned from those large law firms to offer cost-effective solutions for businesses and workers in their workplace disputes without charging that Bay Street and Wall Street prices. I'm also a sessional instructor at Windsor Law, teaching the next generation of labor and employment lawyers a course on labor arbitration and employment law. And finally, I'm an active member of the Labor and Employment Bar as an executive member of the OBA Labor and Employment section, where I regularly give talks on hot topics in employment law. So let's get into today's agenda. We're going to be talking about AI, what it is, its common uses in the workplace. We're going to be talking about human rights related issues, including AI hallucinations and explainability concerns, and the importance of keeping a human in the loop. We're also going to talk about privacy and data protection and emerging regulations. And throughout, we're going to be talking about some employer best practices. So let's get into the introduction. So what is AI? Why does it matter in today's workplace? Artificial intelligence refers to computer systems that perform tasks normally requiring human judgment, such as analyzing data, identifying patterns, and generating content. In today's workplace, AI matters because it increases efficiency, automates routine tasks, and supports faster decision making across organizations. Employers are rapidly adopting AI in HR, legal, and management functions for resume screening, performance evaluation, scheduling, legal drafting, and operational planning, amongst other things. In a recent survey conducted by CDW Canada, 50% of office employees reported a use of AI for work in 2025, whether approved by their employer or not, increasing from 33% in 2024. Moreover, employee access to workplace approved AI tools nearly doubled from 28% in 2024 to 51% in 2025. As I mentioned, AI is no longer an experimental tool, but rather one that has now been integrated into the everyday office environment. And HR is no stranger to those AI tools. And one recent survey by the World Economic Forum estimated approximately 88% of companies are using some form of AI for initial candidate screening. You can go to the next slide. So, as just back one, sorry. With respect to limitations in AI, while AI can improve productivity, it also introduces legal risks, including discrimination, privacy breaches, and inaccurate outputs. Our presentation today is going to explore three key legal lessons on how AI can be useful in the workplace and how to optimize usage while still adhering to legal obligations. This is just a funny cartoon that I picked out about how AI may or may not be misused by your employees. So let's talk about common workplace uses of AI. So the big use of AI right now relates to recruitment and resume screening. It is commonly used as well, though, for performance management and evaluations. Now, with those tools, AI can improve efficiency, consistency, and lead to faster decision making. But without proper safeguards, it can lead to legal risks, including discrimination concerns. We've all seen hundreds and hundreds, or sometimes thousands, of applications for jobs that we post online. And AI can be really, really useful in terms of screening those kinds of applications. But sometimes biased algorithms can disproportionately exclude applicants based on protected grounds in human rights legislation, whether it's gender, age is a big one, disability, or race. And sometimes AI can unlawfully rely on metrics that disadvantage certain groups, whether it's caregivers or employers requiring accommodations. Next slide. AI is also often used to assist with discipline and termination support, as well as legal research and document drafting. Again, without the appropriate safeguards, legal liability can arise, particularly when it comes with wrongful terminations. Employers can be tempted to use AI instead of hiring an employment lawyer, and I know this is going to sound like a sales pitch, but it's really important to note that there are limitations to AI that is out there with respect to contract drafting, or, for example, using AI for disciplinary and termination letters. Because while it can provide a fast solution, it might not be in compliance with case law that changes on a monthly or annual basis. And that convenience can lead to serious legal challenges. For example, if you're terminating someone for cause and you have relied upon AI for the issuance of performance management letters, or cannot explain how you've arrived at a conclusion with respect to decision for termination, you may ultimately run into risks such that you can no longer justify that termination. Likewise, in terms of contract drafting, I have a number of clients that have come to me that have used AI for the purposes of drafting employment contracts, but the tools that are available today, and I'm not suggesting that those tools will not evolve over the coming years or perhaps months, such that they will be up to speed with the current case law. But I've had a number of clients that have brought employment contracts that, frankly, are American-based products that don't understand the intricacies, particularly when it comes to termination provisions and the exacting language that's required for those kinds of provisions. And now, despite having saved money by not consulting an employment lawyer to draft those contracts, they're being sued for wrongful dismissal because the termination provisions are not enforceable. Legal risk can also arise due to the limitations of current AI models in conducting accurate legal research. We're going to talk a little bit later today in the presentation about a case where even lawyers have unfortunately misused the AI in supporting their legal arguments before the court and have been called out by the court for having done so. But also some recent rumblings by, for example, the owners of ChatGPT, and understanding that your inputs into those kinds of products may be subject to disclosure and litigation. And conversations with your lawyer, with your employment lawyer, are protected by solicitor-client privilege. However, conversations that you may be having with an AI tool seeking legal advice are not going to be protected. And there may be inputs that you put into those products that you do not want disclosed in the course of litigation. Let's go to the key legal AI lesson number 1. And we're going to talk about discrimination and human rights liability. It's important to be mindful of bias and discrimination that can arise through the use of these tools. AI-related discrimination happens because sometimes AI systems learn patterns from historical data and simplified rules that often reflect existing workplace bias. If past hiring, performance, or attendance data disproportionately reflect certain groups or impact certain groups, the AI may replicate or amplify those disparities by using proxies such as gaps in employment, availability, productivity metrics, or scheduling flexibility. It's important to note that businesses cannot discriminate against any workers in any way that would be in contravention of human rights legislation, and whether this is perpetrated by AI or by a person. Ultimately, the buck stops with the employer. So you can't rely on an AI product and say, well, it was actually the AI's fault. You yourself, your business may ultimately be involved in a lawsuit if the tool you're using disproportionately or discriminates against a potential applicant, for example. Let's go to the next slide. Employers using AI in recruitment must ensure compliance with anti-discrimination laws like Ontario's Human Rights Code. If you're coming from another province, virtually every province has similar legislation to the Human Rights Code here in Ontario, or if you're a federally regulated employer, the Canadian Human Rights Act. And again, as I mentioned, liability rests with the employer and not the vendor. This can lead to legal risks, as an AI tool will produce biased results if biases in that analysis are based off of biased information. When this information is used, it can lead to unfair outcomes and perpetuate discrimination. Let's go to the next slide and talk about some case examples. As you can imagine, obviously the United States has 10 times our population, so much of the litigation in this space has occurred in the US. It hasn't quite come to Canada yet, but it's often sort of a warning sign or warning shot as to how cases might develop here. So I'm going to talk about a couple of cases that are on the slide and also talk about some other examples that have come up in the news. So the first is a Mobley and Workday case, and that's a class action lawsuit in California where it's alleged that Workday's AI screening tools were discriminatory on the basis of age, race, and disability. And in that case, the applicant, an African-American man over the age of 40 with disability, had applied to hundreds of jobs where those employers were using Workday's screening system. And he was often rejected from those roles either instantly or within hours, which clearly showed that there was no human involved in making those decisions. That case is currently ongoing, but the exposure in that case to Workday is upwards of millions upon millions of dollars. Now, the key lesson to come from a case like this is the importance, and we're going to talk about it throughout today, is keeping a human in the loop. So it's not to suggest that you shouldn't be using an AI tool to screen applicants, but it's important to note that if you are going to use a tool, let's do a spot audit. Let's look at the hundreds of folks that have been rejected. Maybe we look at 15% of those rejections. Are we seeing that certain of those rejected applications are actually candidates that we believe would be qualified for the role? If that's the case, what are we doing to feed back into the algorithm or feed back into the tool to make sure that those kinds of candidates are not being screened out? Again, the key lesson here is not that we don't use AI for the purpose of screening prospective candidates, but that we're making sure that we are conducting our own audit, we're keeping a human in the loop to ensure accuracy, and of course, that we're not violating potentially human rights legislation. In the Baker and CVS Health Corporation case, Brendan Baker was the plaintiff in that case, and he applied for a job with CVS in Massachusetts and was given an interview. And he was asked, along with other interviewees, to answer a set of questions while being videotaped, with questions like, what does integrity mean to you? What would you do if you saw someone cheating on a test? And have you ever acted with integrity? Unbeknownst to Mr. Baker, CVS was using an AI tool, HireVue, to assess potential employees and their truthfulness. And Mr. Baker was not successful for the role following his interview. Mr. Baker ultimately sued CVS and argued that he was subject to a lie detector test without his consent, contrary to state law. And in Massachusetts, candidates must be notified and able to opt out of lie detector tests for interviews. Also, interestingly, in Ontario, we actually have a prohibition on lie detector tests. So it's possible, if you're using a tool to screen applicants via video interview, you may ultimately be failing to comply with a piece of employment standards legislation like the ESA. Likewise, as HireVue was caught up in another lawsuit with a makeup artist in the UK who was out of a job opportunity due to her experience with HireVue. And in that case, the plaintiff was laid off from her role as a makeup artist for MAC Cosmetics. And following her layoff, she was required to reapply for her previous role with a video interview with HireVue, forming part of the assessment. And while she scored full marks on her performance, she did not land the position because her body language was assessed by HireVue's product as poor. And the applicant, the plaintiff in that case, who clearly had significant experience with that employer itself, sued, arguing that the tool that was used by MAC Cosmetics ultimately discriminated against her for body language, not without her consent as well. So again, the key piece in both of those cases here is, the question to be asked of the tool, are biases preventing otherwise qualified candidates from being selected for a role? And is that increasing the potential for discrimination claims and legal disclosure? In this country, we have a duty of good faith and an honest performance underpinning all of our contractual obligations to each other. And if you can't explain, for example, why an applicant has been denied a job despite, for example, in the UK case with MAC Cosmetics, with a person actually having in-seat experience for the role that she was reapplying to, you're going to expose yourself to potential liability here, whether it's breach of the Human Rights Code or breach of that duty of good faith. There's some other case examples that have come out in the US in the news. In Amazon, for example, began developing a tool in 2014. So this is in the early days of AI to screen job applications. And they actually never implemented that tool because it was found that it was discriminatory against women applicants. The models were trained to screen applicants by observing patterns in resumes submitted over the past 10-year period, which mostly came from men and was a reflection of a male-dominated industry. And the models had taught itself to penalize resumes that contain the word women. And although Amazon attempted to neutralize these terms, the machines could not be relied upon to make unbiased screening decisions and was ultimately scrapped. Another example that's been reported in the news relates to iTutor Group. An applicant applied to a job at iTutor Group, an organization that provides English language tutoring services to students in China, and was rejected for the role. And the applicant then resubmitted the same application, but with a younger birth date, and was selected for an interview. The U.S. Equal Employment Opportunity Commission, so their equivalent of the Ontario Human Rights Commission, alleged that the AI software used by iTutor was programmed to reject female applicants over the age of 55 and male applicants over the age of 60. And as a result, 200 qualified older applicants were rejected from the roles that they had applied to solely due to their age. iTutor was penalized as a result and was required to adopt anti-discrimination policies and conduct anti-discrimination training in addition to reporting requirements to confirm attendance at those training sessions. And they also ordered iTutor to pay $365,000 to affected job seekers and to invite selected applicants to reapply. This case actually hits close to home. I've had a client before, a worker client, who, has many years of experience, and as part of their mitigation efforts and a wrongful dismissal action that they've claimed, we're running into the fact that they were applying for numerous roles where they were clearly qualified for, and like the applicant or the plaintiff in the Mobley case, were being instantly rejected. And ultimately, my client is not pursuing a case with respect to the AI, but it goes to show you that if you're over relying upon these things, not keeping a human in the loop, you may ultimately end up in a broader lawsuit that you weren't ultimately expecting. So let's talk about some best practices. So if you choose to implement the use of AI, you should look into the AI tools used and ensure that your organization has a due diligence process to uncover legal, ethical, and operational risks with the AI tools. In addition, you should ensure that there's a human oversight over AI processes and ensure that humans are the final decision makers to ensure that AI is not inadvertently making discriminatory decisions on its biases. Employers should conduct bias testing of data sets and algorithms before deployment, require vendors to disclose training data sources and fairness metrics, use diverse and representative data to train or calibrate AI tools, and implement a bias audit schedule, whether it's a quarterly review or otherwise, or engage a third-party auditors where possible. Again, it's just important to keep note that ultimately liability for these outcomes remain with the employer and not the AI vendor. So let's move on to, or actually one more comment about a tool that has been published by the Ontario Human Rights Commission and the Law Commission of Ontario. Just want to go to the next slide. They published a human rights AI impact assessment tool to help organizations assess their AI tools for compliance with the Human Rights Code in Ontario. Again, as I mentioned, there's very similar legislation across the country that is similar to or identical to the code in Ontario. And as an employer, you can use this tool if AI ends up being used in hiring decisions to evaluate compliance with the human rights legislation. The link is up on or in the slides, and I encourage you to check it out. It helps organizations, number one, strengthen their knowledge and understanding of AI and human rights. Number two, provide practical guidance on AI and Canadian human rights law, and identify some mitigation strategies to address bias and discrimination from AI systems. So we strongly encourage your organization to check this out. It's a free tool that's available to you for you to assess whether or not the AI tools you're using are in compliance with human rights legislation. Let's move on to key legal AI lesson number 2. So there is some uncertainty with respect to how AI tools come to make their decisions, and should a lawsuit arise as a result of the decisions made by AI, the uncertainty in the decision-making process can be fatal in an employer's ability to defend against these claims. For example, in the inability to defend discrimination claims, the key to defending a claim like that is having appropriate documentation and evidence as to why a certain decision that was made was not linked to a protected ground for discrimination, whether it's age, race, creed, disability, sex, sexual orientation, etc. An adverse inference is going to be taken by courts and tribunals if an employer is unable to come up with sound reasoning as to how and why a particular decision was made. And this is particularly so if the other side presents facts and evidence to support their allegations. So consider the case that we were talking about with respect to iTutor, where the applicant had submitted the exact same resume with just a different age or different birth date. Right? How was the employer going to explain why that identical resume ultimately was considered when the other was not, and the only difference was the age? There's also rules in place that we're going to talk about a little bit later today that have started to come through minimum employment standards legislation that's going to require the disclosure of the use of AI tools. Now, it's not a prohibition, but it is a nudge by the provincial government in Ontario that you're going to have to start disclosing when you are using AI tools to screen applicants. Let's go to the next slide and talk about AI hallucinations and legal accuracy. So AI tools operating with incomplete or inaccurate data or based on flawed training data can lead to AI hallucinations. And those occur when AI systems produce plausible but false information. So what we've seen recently in the case law is incorrect legal precedent, for example. And cases are frequently being coming up in the media of AI hallucinating legal case law. And I want to talk to you on the next slide about one of those cases. One of the numerous examples of AI hallucinating case law is in the case of Ko and Lee, which is just on the next slide. A case involving a complex estates and a family law dispute. And the lawyer for the applicant in that case had submitted a factum to the court, which was prepared by her staff with the help of ChatGPT. And it was discovered that there were several references to fictitious cases. One case was linked to an unrelated commercial real estate case. Another link returned to a 404 era. Another case was misrepresented as supporting the principle that the applicant was seeking when it actually had dismissed and was contrary to what was cited. Another case was related to a completely unrelated wrongful dismissal case. And the judge in that case cited potential breaches of the duty relating to the obstruction or interference with the administration of justice, and the lawyer was required to attend a hearing to show cause why she should not be cited for contempt. And if you're a lawyer, you do not want to be in contempt proceedings before a judge. There's been other cases in BC, but it's again clear here, which is if you're using AI, you cannot rely upon it without checking your work. Right? You've got to check your sources ultimately. One of the other things that is not featured on a case example, but one of the things that is also coming up that you also need to be mindful of is a recent speech by the head of ChatGPT or OpenAI mentioning that your inputs into these kinds of products are subject to disclosure and legal proceedings. So, you might ask your lawyer, again, a sales pitch, I suppose, for using employment counsel, but you might ask your lawyer a question like, is requiring, an employee to return to work following a medical leave of absence in a role that's not the same discriminatory? You might ask your lawyer that. Or not having a position available for this person who's been on medical leave of absence. Are we in breach of the Human Rights Code? That conversation with your lawyer is protected by solicitor-client privilege. If you ask ChatGPT that question and you get a response that you rely upon, that conversation that you've had with ChatGPT very well could be subject to disclosure in a lawsuit. Things that you would never have produced in conversation with your lawyer now may be subject of litigation. I am seeing on a day-to-day basis in my practice opposing counsel saying, I want all of your clients' inputs into AI. I want to see what's in there. If you wouldn't want your inputs into AI blasted on the front page of the Globe and Mail or whatever newspaper you read, you need to think very carefully about putting in those inputs. So let's just go on to the next slide and talk about best practices with respect to hallucinations. So, whenever AI tools are used to draft content, you got to verify those citations, whether you're a lawyer, HR professional, or otherwise. And you got to engage in secondary research to ensure that the content being provided is accurate. AI drafted content should be a starting point rather than a final product. Okay. Some of those best practices include requiring qualified employees to verify all AI generated content before it's relied on or acted upon, especially if the decision affects employees or prospective candidates. Again, we're going to treat AI generated content as draft input, not final truth. We're going to limit AI use to approved tools and defined purposes, prohibit unsupervised use for legal HR disciplinary decisions, and provide a right to respond potentially to an employee or an applicant that's adversely affected by an AI-based recommendation, giving them an opportunity to review and contest the decision. So let's go on to our final legal AI lesson. Oh, sorry, let me just talk about this piece of legislation that's come out. So the Employment Standards Act was recently amended with a new obligation requiring employers to disclose the use of artificial intelligence in hiring when a job is publicly advertised. Again, this is not a prohibition. So there's been a number of pieces of legislation that have come out in Ontario over the last number of years with a relatively new provincial government under the Working for Workers series. And there's been a series of nudges by the provincial government to get employers to have conversations about issues that they're concerned about, such as you may have heard about electronic monitoring in the workplace, workplace disconnection. These are not, for example, prohibitions from requiring your employees to work, past specific hours, or prohibitions on monitoring your employees, or a prohibition on using artificial intelligence. But what it is requiring employers to do is to disclose. And so if you're using AI in your screening of applicants and you're an employer with 25 or more employees, that's a key threshold piece here. So if you have less than 25 employees, you don't have to comply with this legislation. If you do have more than 25 or more employees, you are now going to have to disclose in your job postings whether or not you are using AI. So other exceptions to keep in mind, general help wanted sign that does not advertise a specific position is not wrapped up in this legislation. If the work's performed outside of Ontario or if the work is performed outside of Ontario, it's also not wrapped up in this legislation. But employers have to be mindful of this now, effective Jan 1 of this year. If you've got 25 or more employees, this piece of legislation applies to you. Okay, next slide. Okay, so sorry, thanks. Organizations, just with respect to privacy and data protection obligations, organizations using AI tools should remain vigilant regarding potential privacy risks and should be familiar with applicable privacy legislations. It's really important for employers to develop an AI policy, setting guidelines that define how employees should responsibly use AI in the workplace. Another aspect of this too that I'm seeing in my practice is employees misusing confidential information into AI. Again, you want to make sure that you have a policy that exists that prohibits employees or your training employees not to be taking confidential or potentially proprietary information of the organization and feeding it into a public AI tool, which could breach potential confidentiality obligations you have to other third-party vendors, but now is being input into a product where you can't control what happens with those inputs. Creating or drafting a use of AI policy is very, very important and would strongly recommend it. Go to the next slide. With respect to PIPEDA, the Personal Information Protection and Electronics Document Act, it's Canada's federal privacy legislation governing how private sector organizations collect, use, and disclose personal information in commercial activities, which requires consent, transparency, and safeguards to balance privacy rights with legitimate business needs. The purpose here is to protect personal information while supporting electronic commerce and ensuring data is managed responsibly. The Office of the Privacy Commissioner of Canada has examined AI as it relates to PIPEDA. In 2020, the OPC released its key recommendations for regulating the use of artificial intelligence. And the OPC is calling for legislation that is being discussed and has been promulgated to help reap the benefits of AI while also upholding individuals' fundamental rights to privacy. And those include amending PIPEDA to, number one, allow personal information to be used for new purposes towards responsible AI innovation and for societal benefits, authorize these uses within a rights-based framework that would entrench privacy as a human right and a necessary element for the exercise of other fundamental rights, create a right to meaningful explanation for automated decisions and a right to contest those decisions to ensure they are made fairly and accurately, strengthen accountability by requiring a demonstration of privacy compliance upon request by the regulator, empowering the OPC to issue binding orders and proportional financial penalties to incentivize compliance with the law, and require organizations to design AI systems from their conception in a way that protects privacy and human rights. We can go to the next slide. That has ultimately, those guidance or those guidelines has ultimately led to some emerging federal AI regulation, the Digital Charter Implementation Act, which is to replace PIPEDA. It has not yet been passed, and it has the potential to implicate rights under Section 8 of the Charter because of the Privacy Commissioner's powers and certain provisions allowing government institutions access to personal information, which may implicate information subject to a reasonable expectation of privacy. And it introduces three major parts: the Consumer Privacy Protection Act, the Personal Information and Data Protection Tribunal Act, and the Artificial Intelligence and Data Act. This regulatory framework, it continues to be subject to discussion and promulgation, but something just to keep in mind that this sort of area of regulation, whether it's Ontario, federally, it is moving quickly because of the fact that AI now has basically infiltrated all of our lives in all aspects of our lives, whether it's your workplace lives or otherwise. And it is something to keep in mind that you are going to have to keep abreast of the latest developments in the law. Let's go to the next slide. So best practices to incorporate into the workplace. So, I've said it a number of times, human oversight. It's key when using AI tools. Obviously, AI can generate quick and convenient answers, but those answers can often be wrong or misleading. Without human oversight, without a human in the loop, those AI-generated errors can expose organizations to significant legal and financial liability. So key here is to maintain an AI impact assessment, use that Human Rights Commission tool that I referenced, create an audit trail to document what data was used, how the AI system functions, the rationale for each decision, and who approved it. Let's go to the next slide. Policies and procedures are key. A formal AI policy should be implemented to ensure responsible and legally compliant use of AI. Without a policy on AI, organizations can be exposed to an authorized use of AI and the legal, financial, and reputational risks that follow. If you've got an employee, for example, that misuses AI, misuses confidential information in an AI tool, and if you don't have an AI policy, for example, that prohibits that kind of conduct, you're going to have some difficulty terminating that person for cause. If you want to be able to protect your organization and the management of your workforce, for example, ensure that you're able to terminate folks because they have not complied with your policies, you've got to have that policy. You've got to bring it to their attention. You've got to train it to them and train also them on the consequences of that kind of breach. Got to have clear documentation and auditing standards to ensure that your decision-making process is understood. Let's go on to the next best practice. Compliance and spot checks. AI models have got to be regularly checked for compliance with legislation and human rights and ethical standards. While it is the status quo that liability rests with the employer, it's also possible that the state of law could change. It's important to review your vendor contracts to ensure a clear understanding of any indemnification provisions related to human rights and data quality. And if ultimately your vendor is to be bear liability, in the absence of those indemnification clause, then you're going to need to understand the indemnity provisions in your contracts with vendors, which is going to become even more critical without those kinds of indemnity provisions. Next slide. AI training, staff should be regularly trained on AI. Attendance should be recorded at these training sessions, and employees should sign an acknowledgement that such training was received. And then finally, just some, key takeaways here. You know, AI offers, efficiency, but creates legal risk. Transparency, accountability, and a human in the loop are absolutely essential. You've got to proactively manage AI use, and just be mindful that the legal landscape is evolving. It is ever changing. We've got signals from the federal, provincial governments that new legislation may very well be introduced. Keep in the loop with your employment law advisor because ongoing compliance is going to be critical here. Thanks very much.
Thanks so much, Alex, for that really insightful session. We do have one question in the chat I think we have time to get to. If
Sure.
candidates are asked to complete a behavioral assessment as part of the recruitment process, is that considered the use of AI for the purposes of disclosing AI use and assessing legal risks based on potential AI bias?
Yeah, so I think I need to know more about that behavioral assessment. You conducting your own behavioral assessment, separate and aside from an AI tool, is not going to, bring this into the ambit of what the Employment Standards Act in Ontario is seeking to regulate. But if you are using a tool, an AI tool, for example, to assess, someone's behavior, we've talked about that case, the CVS case, for example, it's possible that that could fall into the ambit of disclosure. So I need to know a little bit more specifically about the tool. Certainly feel free to reach out. We can have a discussion about it. But, there's a definition that's contained in the slides about what the provincial government views to be AI. And you should consider that definition in conjunction with what you know about the tool.
Awesome. Really quickly, if we can squeeze it in, what is a vendor indemnity policy?
Yeah, so in your contracts with whatever AI company you might be using for a specific tool that you have, there are going to be provisions that talk about risk allocation, right? So there's going to be something in that contract that talks about if you are sued, specifically with respect to improper decision making related to AI, what does that provision specifically say about who holds the bag if you're sued? So in considering, using a tool, you'll probably have it in a licensing agreement or otherwise. If you are negotiating a contract with a third-party vendor for the use of their tool in your workplace, you need to be looking at those indemnity provisions to see what would happen if ultimately you are sued, because the contract will typically spell that out. And it's something to be mindful about as you're negotiating those contracts, because as you'll have seen, the employer is primarily going to be wearing the bag here. And if for or holding the bag, excuse me. And if you've got a contract that has some sort of provision in there that spells out or something that might be off market, you're going to want to have a lawyer review that.
Wonderful. Thanks for that description there, Alex. Well, I think our time is up for today, everyone. Thank you so much for taking the time to spend part of your afternoon with us. And thank you, Alex, for your contribution. You will receive a copy of the recording and slides following this session. And if any other questions come filtering through, I'd be happy to put you in touch with Alex through those. So again, thank you so much, everyone. And we'll see you on the next one. Take care.
Thanks, everyone.